All right, in our case review today, we'll be looking at the Igwe against the State 2021 Supreme Court Authority on issue of proof of evidence, affording defendant time and facilities to prepare his defense. And in this case, from the fact, the the defendant who raised the objection at the trial court uh, made his grant of objection was that the proof of evidence served on him or served on the defendant was incomplete. So the prayed the court to quash the information against the defendant. So what happened was that the defendants were charged at the magistrate court on offense of attempted murder and conspiracy. So the magistrate court, seeing that it has no jurisdiction to try the matter, referred and transmitted the case file to the Attorney General, who preferred his opinion and charged the defendant at the High Court. Then at the High Court, the information was filed and proof of evidence were served on the defendant. The defendant, before they took their plea upon arraignment, raised this objection that the proof of evidence served on them was incomplete and asked the court to quash the information against them. So, and the court ruled that no, this cannot form a ground of quashing the information on this issue. That when the matter came to the Supreme Court, that the Attorney General has the discretionary power to determine which evidence is material and which one does not material, to know the statement that can form part of the proof of evidence. So these were the issues, and the court looked at what is prima facie case. What's the meaning of prima facie case? And the court also looked at the grounds for quashing information of charge. The court also looked at the content of proof of evidence. The court looked at so many other issues, but we will concentrate on these three issues because these were the major issues that were considered in the case. So on the meaning of prima facie, the court described it as that for that to be a prima facie case, that there must be an offense disclosed on the proof of information, and there must be a link or ground linking the defendant to the offense. So for you to say there is a prima facie case against the defendant. And the court also looked at an issue of serving the defendant proof of evidence, which is provided under section 36 sub 6 paragraph C or paragraph B of the 1999 Constitution. The court looked at it and defined what is facilities. The court defined that section stated that the defendant must be afforded time and facilities to prepare his defense. And here, facilities simply means resources and any other thing that will aid the defendant in preparing his defense. And this obviously means all the statements that the police took during the investigation or material or whatever that form part of the evidence which the police gathered during investigation. Those things should be made available to the defendant. So these are the description the court gave to the term facilities. And some other issues, the court also looked at, this case took place in Anambra State, and court looked at section 146, paragraph C of the Administration of Criminal Justice Law of Anambra State 2010, and stated that these facilities or proof of evidence should also contain names, address, and statements of witnesses that the prosecution may not even intend to call. So he has to include it when serving the defendant. So this was the major contention, and I think what the Supreme Court ruled in affirming or dismissing the appeal was this is particular. There was a dissenting judgment by one of the justices of the Supreme Court who relied on this and dissented on the judgment that said that no, that the prosecutor must include even the statement, names and address of those witnesses he may not even intend to call, because what is material to the Attorney General maybe what the Attorney General sees as immaterial to him may be material to the defendant. So, in affording all the parties opportunity to be heard and defend or prosecute the case, all the materials, whether those he intends to call and those he may not intend to call, should be afforded to all the parties for fairness to be. So, okay, and what again did we look at? They got looked at the grounds of quashing and information. The grounds for quashing information is where the information or charge did not disclose any prima facie case against the defendant. In other words, when a proof of evidence is served on the defendant and he went through it and see that there is no prima facie case against him for the court to proceed, or that will require the defendant to make some explanation, the court can quash the information, the court can quash the charge. So, thank you. So, we urge you to subscribe and also follow up with our case reviews on YouTube, and also read our posts on WhatsApp. Thank you.